This was a tough video to edit, so please make sure you watch all the ads. We're going to do today's video really, really differently, okay? I blame Mshololo for this. And I'll explain why. Before you start typing, I'll explain why. But let's listen up. I'll be back with the rest of my commentary.
Yeah, I've heard you. But you see, you're investing the logic.
Yes.
I know it is, the Act says I can do it.
Yes.
167
but,
and 186. But can you, because you feel your client is being shortchanged.
In terms
and then
of
this judge is so stupid, he doesn't see this point.
And
you make an application that, Judge, invoke section 167.
That's
what I'm asking.
In terms of the case law that is available, my lord.
Yes.
That is unknown.
Unknown.
Yeah.
Okay.
I have not come across case law that actually shows that the state or the defense can actually recall the witness to close the lacuna in the case.
Okay, Mr. Mnisi, sorry, Ramsepidi, you agree with your colleague?
As the court pleases, my lord. My lord, stricto sensu, it says, in the strictest terms of the Act, it says the court may recall a witness for clarification purposes, my lord. However, in answering the court's question, in the Shabir Sheikh matter, it was the defense that recalled a witness for clarification, my lord.
Okay, fine. No, I'm aware of the case. Mr. Mnisi, educate me.
By convention, my lord, I think there is no impediment from one of the litigants to request the court, and the court can then use his discretion.
That's it. Happens every day, no? You're right. Yeah. Let's hear, unless Mr. Nxumalo and Ms. Mshololo say you are wrong.
No, I'm not saying it's wrong.
No. Okay, fine. What do you say?
The court can use its own discretion on the application.
No, but you're not listening to Mr. Mnisi. Tell him what you said, Mr. Mted. Tell him what you said. Repeat what you said. I don't think he understood you.
I understood.
Mr. Nxumalo, Mr. Mnisi, yeah. Just repeat what you said before. Just before now. By convention, that's the... No. Once you have said it, he'll understand it. He didn't catch you.
I've said, my lord, by convention, there is no impediment on the part of the litigants to request the court or to make an application or to ask for an indulgence from the court to record a particular witness. And then the court in those instances can then exercise their own discretion.
Okay, fine. Mr. Nxumalo.
I'll fall in the same trap, my lord.
You follow?
I agree with my colleague.
Okay, all right.
Yes, I agree with my colleague fully.
Ms. Mshololo?
My lord, both these provisions, they are very clear.
Deba?
They are very clear.
Okay.
To say the court may. It doesn't say any party during the proceedings.
No, you've missed the ball again.
Yes, my lord.
The court, the duty rests with the court.
Yes, my lord.
Now, the incantation by the defense, when they realize that they want the court to exercise its discretion in terms of 167 and 186, can they argue and persuade the court to utilize that discretion which rests on the court? That's the question.
My lord, can I make my submission?
Yes.
Okay. My lord, my first submission is that the section is clear. 167 says the court may. 186 says the court may. That's my submission, my lord. These two provisions says the court may. It doesn't say any party. However, my lord, if it is at the instance of any of the parties, either between the state or by the defense, the court must use its discretion.
Okay, fine.
Yes, those are my submissions, my lord.
Okay, thank you.
No,
Yes,
the Act, it's very clear to say it's the court, not by any party.
Okay, Mr.
Thank you.
Baloi, any new wisdom?
As a court, please, I go along with the submissions of or counsel, I think we are all ad idiom that any party can request the court to invoke these provisions.
Okay. Counsels for number 3, 4, and 5. The gravamen of the application by the state is that they want to recall Lieutenant Colonel Steyn, the reason being for him to clarify only 2 aspects that appear on page 23, 26, and 27 of his affidavit. In support of this application, the state alleges that Exhibit O, Exhibit O, 1 in brackets, Ms. Withelingham's affidavit dated the 16th of May, 2024, which is Exhibit JJ1, she sets out the transactions for 2 telephone calls, namely one made on the 2nd of August 2014 and one made also on the 15th of October 2014 between Ms. Nxumalo's number, and these calls were received by, allegedly, or made by accused number 5. And further, that Lieutenant Steyn locates the 2 calls at the time as the same as those which are reflected in section 205 downloads of the cell phone numbers. It is pertinent to mention that Lieutenant Colonel Steyn testified, I think, in August last year, and that Ms. Pinky Battlingham testified in July this year. The state differentiates between the duties and titles as to what Ms. Pinky Vanningham's capacity is, and they refer to her as a supervisor in the Forensic Liaison Service section of Vodacom, whilst Steyn is apparently referred to as an analyst of cell phone information. Mr. Baloyi, on behalf of the state, argues that this distinction is very vital because it is the one that allegedly brings about a dichotomy regarding its scope as practiced by either Ms. Pinky Wallingham and Lieutenant Steyn, and says this very difference in the description of the expertise exercised by these 2 different witnesses has given rise to confusion, which the state says entails matters which are not clarified, and which the state further says when it argues that the defense says there is a contradiction relating to the 2 aspects of these 2 telephone calls. Further, the state argues that the crux of the matter also revolves around these 2 calls as reflected, 1, in the PDF disk proffered to the state by Vodacom, and also what is referred to as the Excel spreadsheet, which encapsulated 2 different numbers, which are allegedly also supposed to have been sent or having been transacted between Kelly, Nxumalo, and accused number 5. These numbers, as correctly stated by Mr. Mnisi, they are dissimilar and they are materially different. Or he says there are material differences. And also he goes further and says that difference, in his view, it was intended to pervert the course of justice. I'll leave it at that. It is correct that Ms. Pinky Vithilnium was not able to explain the origin of the two numbers of the two transactions allegedly transacted by Ms. Kelly Khumalo and accused number 5. And these two numbers allegedly were made at the very same time as alleged by Ms. Pinky Willingham in the PDF disk supplied by Vodacom to the state or the police. And she says she can only testify on the numbers which are encapsulated in the PDF disk. She cannot testify as to the numbers which are encapsulated in the Excel spreadsheet because those were not supplied by Vodacom. The numbers which were supplied by Vodacom are encapsulated in the PDF disk, not in the Excel spreadsheet. He doesn't know how the police or the state went about transposing those numbers onto the Excel spreadsheet. She doesn't know. Two different distinctive application of the two surfaces, the PDF and the Excel system. She knows nothing about that. But in this court, we know that, as Mr. Mnisi states, there were two distinct numbers, two sets of distinct numbers relating to the two calls made allegedly to Kelly Khumalo by accused number 2 or vice versa. The state's contention is that the statement made by Advocate Mnisi to the effect that there was fraud, there was uttering, defeating the ends of justice, or plain language, criminal activity intended to mislead this court and intended to pervert the course of justice, and consequently that charges would be laid or a complaint would be laid against even Pinky Willingham. And consequently, the state is of the view that these are very serious allegations which must be investigated. The allegations ought to be put to Colonel Lieutenant Steyn, and that he must be given the opportunity to comment, because Pinky Willingham is being vilified on her own mouth. She's being vilified for an action or conduct which she never participated in. And I have said that amounts to reputational damage because she's an expert witness. She gives evidence throughout the courts in South Africa. I first recall meeting her about 15 years back or so, or 20 years back in a criminal court. So I agree with the state when they say Steyn must come and account, because Willingham can't be
Wait a minute. Is he getting emotional for that Pinky is being attacked for her professional opinion and he's ready to fight for her? Like, is it just me? Let me know if you see he's almost tearing up.
Further, the state's contention is that this application is brought in order for Lieutenant Colonel Steyn to come and clarify the nature of these two calls that accused number 5 allegedly is said to have made to Ms. Kelly Khumalo. That is, as to whether these calls were made using data or internet, or whether they formed part of incoming or outgoing calls regarding AMA data. And this court is also baffled, I can tell you that, by the evidence given by Colonel Stein, because this is what he says under cross-examination by Ms. Mshololo on the question as to how did he establish that the various numbers that he mentioned in his affidavit are being associated with accused number 5. And this is what he said. That is correct, but also I can also mention, after I received the information from Brigadier Ginanda, I throw it into the I throw it into the AMB notebook database, and then the linkages come with the section 205s and the cell phone downloads. That's how he explains it. To me, it's baffling. And he never explained how he goes about this. It's like asking a Michelin chef in France, Paris, how does he prepare duck? And then he says, I throw it. I received the information from Brigadier Ginanda. I threw it into the AMB notebook database, and then the linkages come with the section 205s and the cell phones downwards. That is explanation. I don't understand that Bible book. I don't. So all the state says wants to happen is that Lieutenant Stein must come and clarify the issue of the 2 calls, not to give new evidence. That's how I understand the application. And not to correct his evidence, to clarify his evidence. That's how the application is couched. So the state says it is essential to recall Lieutenant Stein in order to clarify this aspect so that the truth can be determined in order for the court to arrive at a just decision of the case. Okay, that is the gist of the application. Now, Ms. Mshololo and the other counsels, if I'm correct, will try to define what are the duties of this court if it is approached or persuaded by a litigant, either the state or the defense, to say that because the court did not meromoto invoke 167, section 167, which I'll just read, and 186. I did not. I was entertaining an application. Now, this is what 167 says. The court may examine witnesses or persons in attendance. I'll just read it. The court may, at any stage of criminal proceedings, at any stage, meaning even at this stage, even though I never invoked it. This is what I understand it to mean. The court may, at any stage of criminal proceedings, meaning even during an application, like this one, examine any person other than the accused who has been subpoenaed to attend such proceedings or who is in attendance at such proceedings, and may recall and re-examine any person, including an accused, already examined at the proceedings, and the court shall examine or recall and re-examine the person concerned if his evidence appears to the court essential to the just decision of the case. And 186 says this, so that we keep that also in mind. Section 186 says the court may subpoena witnesses. The court may, at any stage of criminal proceedings, subpoena or cause to be subpoenaed any person as a witness at such proceedings, and the court shall so subpoena a witness or so cause a witness to be subpoenaed if the evidence of such witness appears to the court essential to the just decision of the court. Okay. Sorry. Mr. Because according to him, it's not encapsulated as an application brought in terms of section 167 or 186. Sorry. Sorry, so much stuff here. I quote Du Toit and De Jager in their famous commentary on the Criminal Procedure Act. At page 2-95, under section dealing with section 166, this is what the learned authors say. Recall for cross-examination. The right of the defense to recall a state witness for further cross-examination as part of a right to a fair trial was considered in S versus Rautenberg, 2014, 1 SACR, Johannesburg High Court, where the counsel wished to recall a witness because he had forgotten or had failed to put to a witness crucial aspects of an accused version for comment. This application was vigorously opposed by the state because, according to the state, the counsel's explanation for not having put these crucial aspects to the state witnesses regarding the accused version, the state held that they were not entirely satisfactory.
So at the beginning of this video, I told you that I blame Mshololo, okay? I blame Queen Mshololo for this outcome. Why? Why, you wonder? Are you ready to fight me for my response? I blame Mshololo because she made me believe, okay? She made me believe. She made me go against my better judgment. She made me believe. She made me understand her arguments together with Mnisi, together with Nxumalo. But it's really Mshololo who turned me around. And that is why I blame her. I knew better. I was with Ngome Zulu and Ramasipili. Don't waste time. Don't bother yourselves. Don't object. Let Stein come, ask the questions, and keep it moving. I was team that. And you can go back to my original video Monday morning before everything. I said, guys, let Stein come. Then Mshololo did a fantastic job convincing me. And I know she convinced a whole lot of you in the comment section because I also saw you confessing as well in the comment section that first you did not want Stein to come on this, that you wanted Stein to come on the stand. But then you know what? The defense did a fantastic job and convinced us otherwise. So for that, I take my hats off to you, defense team, Nxumalo, Mnisi, Mshololo. You guys did a good job. I hope you don't take this as a loss. This reminds me of the trial within a trial, okay? I believed then too, okay? I believed the judge was going to give the right judge. But I learned my lesson then, okay? I learned my lesson then. I learned that the judge is very transparent. He gave us so many clues yesterday. He gave us so many clues during Mnisi's talk, during Mnisi's submissions, during Mshololo's submissions, the judge was not silent. He was giving us his opinion, okay? Especially when he gave the hint about the ABM throwing database case, whatever that is. He too never asked what that was last August. And now that Stein has a chance to come back, suddenly the judge is so interested in this little conniption, gadgety, software invented thing that Stein has. You know what? It is what it is. Stein is coming, ladies and gentlemen, in case you missed that. Stein is coming back. Stein is excited to be back, okay? He's written his affidavit. It's 90% done. He is ready to answer the question regarding the two things. The state promises there'll be no new evidence. They'll be focusing on the 3 pages and only the 2 numbers. Do we believe the state? Type of 1, if you believe the state, and type of 2, okay, if you know better. Okay, if you know better and you know the state is planning a whole ambush. Excuse me for that. I'm not going to edit that out. Wow. This was a hard video to edit, guys. This was a hard video to edit. If you've made it this far, I hope you watch the ads, okay? This was a lot of work, a lot of emotions, because Judge RATHA did the ratification, okay? Stein comes back. We wasted our time yesterday going through. Ngomezulu told us though, but Ngomezulu tried to tell us. Ngomezulu should have just said, when you see, be quiet. Blink twice, send help. Wow, what a day. What a day. Yeah, those are the words of Judge RATHA. Of course, he quotes some case. We don't care. Okay, we do not care. To me, at this point, he should have just said, don't bother with the submissions yesterday. I wanna hear from Stein. And how emotional he got. First of all, Mnisi never said Pinky is one of the people that is putting a case against. He never said that. He never called Pinky Van Dillingham fraudulent. It was very clear that it was towards Stein, which is why Judge RATHA was insistent yesterday, if you remember, who is the author? Who is the author? Who is the author? And when the court asks you a question, Mnisi, you must answer. Now tell me. And Mnisi then says, Colonel Stein. So where does this Pinky definition come up? And he's almost tearing up. Like, what? What are we doing? And he tells us she testifies throughout courts throughout the whole of South Africa, and it's bringing her professional reputation at stake. Are you kidding me right now? What about justice for SENZO MEYIWA? What about justice for the MEYIWA family? What about justice for the 5 accused? Are you gonna tear up for them too? For Pinky? Oh my God! You know what? I don't want to be dragged into the court to answer questions. I'm just gonna pause my commentary on that with regards to RATHA and his emotional outburst with regards to Pinky. But then you know what? He sends us some little fairy dust, okay, to soothe our souls, okay, because our souls are broken right now. He sends us some fairy dust and he says that he is baffled by Stein's method of working, that he received some data from Gininda and then he throws it into the whatever case database and then it tells him the numbers. So he says he is baffled by that. So let's see what Stein cleans up and says about that. Okay. But he clarifies and he says Stein is coming to clarify, not correct or give new evidence. Ngomezulu already said, sure. Why are they 20 pages? We're talking about 2 numbers here. Why is the state handing out 20 pages? It's giving new evidence. But you know what? Mshololo, Nxumalo, and Mnisi. This is Judge RATHA. You can tell that this became personal. Remember I told you yesterday in my video earlier today, I said Judge RATHA, the defense warned him, Nxumalo, Mshololo, and Mnisi warned him that he cannot allow this into, he cannot allow Stein to come back. And they warned him, and that they did. I clocked it, okay? They surely did. And Judge RATHA is like, you think I didn't notice what you guys tried to do yesterday? You think I didn't notice you guys telling me how to do my job? With quoting section 167 and 185. And let me tell you something, I didn't even use that. I didn't even use that to make my decision, even though section 167 and 185 allow me at any given time. Okay? I am Judge RATHA and I do as I please. Mic drop. That's it from me today, Mzansi. Please remember to like, comment, and subscribe if you're joining our channel for the first time. This is Mzansi Unfiltered. Feel free to join the family. Hit that subscribe button. Okay, hit that subscribe button if you want to hear more commentary from myself. I also have another channel, the GNU Unfiltered, where we talk everything South Africa. Okay, let's talk about the Olympics. Let's talk about what? So much more. Okay, there's so much more going on. We hear Julius Malema has given his opinion on the half Nigerian, half Malawian Miss SA. It's a lot, okay? It will be on the other channel. I'll have time to upload there this week. So make sure you join me over there. Help me get monetized on that channel. Thanks so much for watching. I definitely appreciate each and every one of you. Please remember to like, comment, and subscribe. You already know. I'll catch you in the comment section down below. If you're watching from outside the club, it's time to join, okay? Let it go. Let it go. Let go of the stubbornness. Be transparent. Come on in. Be a family member. Take a seat. We have so much space here. Thanks for watching. I'll catch you on my next upload.